Hi everyone, welcome again to another lecture, to the continuation of the lectures in Rules of Civil Procedure. We now go to Rule 2, Cause of Action. It is actually the beginning of civil actions. Okay, so every civil action starts with a cause of action. What is a cause of action? A cause of action is the act or omission by which a party violates a right of another. Okay. So a civil action is commenced by the filing of the original complaint in court. Now, before you file a complaint in court, you have to have a cause of action because it is the reason why you filed a complaint in the first place. That is the reason why Section 1 of Rule 2 states that every ordinary civil action must be based on a cause of action. Okay, so the general rule is there should only be one case or one suit for a single cause of action. You cannot divide it, you cannot split it. Okay, there is only one suit for a single cause of action. A party may not institute more than one suit for a single cause of action. Now, what is the effect if you file two or more cases for a single cause of action? Okay, so the filing of one or a judgment upon the merits in any one is available as a ground for the dismissal of the others. Okay. What is the reason? Why is it important to determine the date of the filing of a civil case? It is important to determine prescription of actions because the date of the filing of an action interrupts the prescriptive period. Okay. Also, uh, the reason why is there a need to have a cause of action before you can file a civil case. The reason is to prevent persons without any right, title, or interest to prosecute an action. Okay. It is to prevent the prosecution of actions by persons without any right, title, or interest in the case, to require that the actual party entitled to relief be the one to file the action, and to avoid multiplicity of suits and to discourage litigation. Okay. What is a cause of action? It is the act or omission by which a party violates the right of another. A cause of action has several elements. First, there must be a right in favor of the plaintiff. Okay. Second, there must be an obligation on the part of the defendant not to violate the said right. And third, there must be an act or omission of the defendant violating such right and entitling the plaintiff to file a case to enforce or protect the right or to prevent or redress a wrong. Okay. Now, in every complaint, okay, you have to state or allege the cause of action. The right of the plaintiff, the violation on the part of the defendant consisting of the act or omission that violated the right, and it must be stated sufficiently in the complaint. Okay, a cause of action is sufficient if a valid judgment may be rendered if the alleged facts were admitted or proved. Okay. Now, if you move to dismiss on the ground of failure to state a cause of action, there is already a hypothetical admission, okay, of the facts stated in the complaint. When the defendant raises defense of no cause of action or failure to state the cause of action, it is equivalent to a hypothetical admission of the material facts alleged in the complaint. However, under the new amendments, failure to state a cause of action is no longer available as a ground for a motion to dismiss. There are only 4 grounds allowed by which a motion to dismiss can be based: lack of jurisdiction, litis pendentia, res judicata, and prescription. Now, failure to state a cause of action is not among those grounds. So you can no longer move for dismissal on the ground of failure to state a cause of action. However, it is also important to distinguish between failure to state a cause of action and lack of cause of action. Failure to state a cause of action is in determining whether or not the complaint states a cause of action. The court is faced with the issue of the sufficiency of the allegations in the pleading. Only statements in the complaint may be considered without resorting to external facts, without regard to any defense raised by the defendants. So, in failure to state a cause of action, the one which is defective is the complaint. So you examine the complaint. If in the complaint it is not clear what is the act or omission that violated the rights of the plaintiff, there was failure to state a cause of action. You only limit the examination to the allegations in the complaint. That is the reason why there is a hypothetical admission that even if all the allegations in the complaint are true, okay, still, okay, the plaintiff has no right to file the complaint because of there was failure to state a cause of action. On the other hand, lack of cause of action is lack or insufficiency, or it refers to the insufficiency of the factual basis of the action. This is determined after the stipulations and admissions are made or after the conduct of hearing on the merits of the case. It can be the basis of a demurrer to evidence. So lack of cause of action means that there was already a presentation of evidence that has been held. However, even if the evidence are collated, okay, the evidence would tell that the plaintiff has lacks cause of action. Okay, so in that case, since the plaintiff was not able to prove the right as well as the violation of the right, it can be a ground for demurrer to evidence. Okay? We have the case of DPWH versus Manalo. So in this case, the petitioner insists that the respondent's complaint failed to state a cause of action. So this is a case for expropriation, wherein the respondents are have properties, houses, okay, within the property which is being expropriated. Now, DPWH maintains that the respondents are only entitled to financial assistance and not just compensation, equivalent to the replacement cost, because they were only professional squatters who may be summarily evicted. On the other hand, the respondents claim that their cause of action as owners of the structure that petitioner demolished for the extension project. So what was the cause of action in the complaint filed by the respondents? It is for to claim payment of just compensation because they are the owners of the structures which was used or demolished by the government in order for their construction project to be built. Okay, so was there a cause of action? Okay, the Supreme Court said failure to state a cause of action refers to the insufficiency of the allegations in the pleading. Lack of cause of action refers to a situation where the evidence does not prove the cause of action, or there is insufficiency of the factual basis for the action. Failure to state a cause of action may be raised at the earliest stages, but lack of cause of action may be raised at any time after the questions of fact have been resolved on the basis of stipulations or evidence presented. So in the first situation, the motion must be made before a responsive pleading, and it can be resolved only on the basis of the allegations in the initiatory plea. On the other hand, in the second scenario, the motion to dismiss must be filed after the plaintiff rested her case. So the important thing to remember in the case of DPWH, in determining whether or not there was failure to state a cause of action, okay, you should confine yourself to the four corners of the complaint. Okay, the analysis should be confined to the four corners of the complaint and no other. Thus, an examination of the complaint is necessary. So in this case, the complaint sufficiently states a cause of action because the respondents are owners of the residential structures and they have rights, and petitioner has the obligation to respect that right. Now, the petitioner's inaction to pay them just compensation is what violated their rights. In the case of Umapak versus Bright Maritime, since the cause of action requires as essential elements not only a legal right of the plaintiff and a correlative duty of the defendant, but also an act or omission of the defendant in violation of the legal right, the cause of action does not accrue until the party obligated refuses to comply with its duty. So gumapak is important because it outlined the elements of a cause of action. So the existence of a right of the plaintiff, the obligation on the part of the defendant to respect that right, and the act or omission which constituted the violation of the right of the plaintiff, which was committed or omitted by the defendant. So as long as the third, the act or omission, okay, of the defendant violating the right of the plaintiff has been committed or omitted, there is no cause of action. Okay. So in this case, when petitioner filed his complaint with the labor arbiter, he did not attach any medical certificate showing his fitness. Remember that in order to establish your cause of action for compensation for work-related injury, okay, you have to establish the causal connection between your work and the illness or injury that you sustained because of your work. So in this case, he filed this complaint without attaching the medical certificate showing his illness. So the complaint itself failed to state a cause of action. So petitioner has no cause of action as he was unaware of his disability at the time of the filing of the complaint. Remember that the burden of proving the causal link between the claimant's work and the ailment suffered rests on the shoulders of the claimant. The petitioner failed to adduce concrete and sufficient evidence to prove that his illness is work-related. Okay, we now move to the case of Celerio versus Bangkasan. Again, the court reiterates that it is only when the last element occurs or takes place that it can be said that a cause of action has arisen. Okay, no cause of action arises until there is a breach or violation by either party. Upon the occurrence of a breach, a cause of action exists, and the concomitant right of action may then be enforced. Okay, a cause of action based on a written contract accrues when the right of the plaintiff is violated. So in this case, when petitioners breach the deed by failing or refusing to vacate the subject property on the date agreed upon. Now, this was interrupted when the parties executed a compromise agreement. So, when the extrajudicial demand was sent, it was made within the prescriptive period because there was an interruption of the period of prescription because of the execution of the compromise agreement. Okay? We have the case of Aquino versus Yason. Okay, in the case of Aquino versus Quezon, again, the court reiterated the distinction between the two grounds for dismissal of an action at that time. Failure to state a cause of action and lack of cause of action. So failure to state a cause of action refers to the insufficiency of the complaint itself, while lack of cause of action refers to the insufficiency of the evidence, okay, to support the cause of action, the factual support of the cause of action. The ground of lack of cause of action is not one of the grounds for a motion to dismiss, and hence not proper for a resolution during a preliminary hearing. The trial court erred in receiving evidence on the ground of lack of cause of action during the preliminary hearing. In determining the existence of a cause of action, only the statements in the complaint should be considered. It is error for the court to take cognizance of external facts to hold preliminary hearings to determine their existence. In determining the existence of a cause of action, only the allegations of the complaint may be considered. To do otherwise would be a procedural error and a denial of the plaintiff's right to due process. In this case, petitioners allege that they had an interest over the subject property by virtue of a deed of sale. Hypothetically admitting these allegations as true, as is required in determining whether a complaint fails to state a cause of action, petitioners may be granted their claim. Clearly, the complaint sufficiently stated a cause of action. In resolving whether or not the complaint stated a cause of action, the trial court should have limited itself to examining the sufficiency of the allegations in the complaint. It was prescribed from inquiring into the truth of the allegations in the complaint or the authenticity of any of the documents referred to in the complaint. So remember, in failure to state a cause of action, the court has repeatedly stated that only the allegations in the complaint should be considered. The court cannot conduct a preliminary hearing and receive evidence. Okay, because in failure to state a cause of action, the allegations in the complaint are hypothetically admitted. Now, in lack of cause of action, okay, it refers to the insufficiency of the factual basis of the complaint after the court has already received evidence and the plaintiff already rested his case. So in this case, the basis for the dismissal of the action is a demurrer to evidence, which can be filed after the plaintiff has already rested his case. Okay. So if you have a cause of action, you cannot split it or divide it, but you can join several causes of action in one. Okay, again, if you have a cause of action, a single cause of action, you cannot split or divide it. Okay, and file several cases with only one cause of action. However, if you have several causes of action, okay, you can combine them in one suit, okay, subject to the rules that you will learn later. Okay. The general rule, a party may not institute more than one suit for a single cause of action. If two or more suits are filed for a single cause of action, the filing of one or a judgment on the merits in any is a ground for dismissal of the others. Remember here, we're talking of two scenarios. You have a single cause of action, okay? If you have a single cause of action, you can only file one case in order to vindicate or redress that violation of your right. Okay? You cannot file two or more cases based on that same cause of action. If you file another case, for example, you already filed one case, and then you filed a second case involving the same cause of action, the mere filing of the second case, okay, the defendant can move to dismiss the second case on the ground of litis pendentia. Okay. In the same manner, if you filed a case involving one single cause of action, and there is already a decision which is not favorable to you, now you file another case involving that same cause of action, okay? The judgment on the merits that was rendered in the first case can be a ground for a motion to dismiss on the ground of res judicata to dismiss the subsequent case that you filed. Okay. The consequences of splitting a single cause of action are as follows. The filing of the second and subsequent cases based on the same cause of action is a ground for dismissal of the other actions. When a judgment on the merits is rendered on any of the actions, judgment shall be a ground for the dismissal of the other cases. Okay, for example, if there is a loan which was secured by a real estate mortgage, okay, and the debtor fails to pay his loan obligation, okay, there is a single cause of action. What is that? The violation of the right of the creditor to collect the payment from the debtor. Okay, so since there is a single cause of action, the creditor only has one or single remedy, okay, for the violation of his right to collect. And what is that? He can choose either to foreclose the mortgage or to file a case for collection of sum of money. Okay? He cannot institute both. Okay, because there is only one cause of action. If he files a foreclosure case, okay, then the proceeds of the foreclosure sale will be the one used to pay off the loan. If he files a collection case, he can no longer foreclose the mortgage. Okay? Uh, in loan contracts, in the case of Marilag versus Martinez, in loan contracts secured by a real estate mortgage, the creditor has a single cause of action against the debtor, which is to recover the debt through an action for collection of sum of money or a real action to foreclose the mortgage. Said remedies are alternative, not cumulative or successive. If the creditor opts to foreclose the mortgage, he waives the action for collection of debt, except only for the recovery of the deficiency deducting the bid price in the auction sale. Okay? We now move to the case of Villaroman versus Alasiaga to illustrate what is meant by splitting a single cause of action. So in this case, petitioners Florante and Carlos are the heirs of Agripina. Now, respondents are the heirs of Jose, one of the registered owners of a parcel of land. Jose, during his lifetime, sold a land to Florentino. Now, despite full payment of the purchase price, Jose failed to deliver and transfer the title of the land to Florentino. And then Florentino later on sold it to Agripina. Now, the title to the property remained in the name of Jose without being transferred to Agripina, even after he died. So, after the death of Jose, his wife, Felicidad, allegedly caused the execution of a kasulatan ng bilihang ganap, okay, which involved the absolute sale of the land in favor of Agripina. Now, the respondents, who are the heirs of Jose, okay, filed a case for annulment of deed of absolute sale and reconveyance of the property, subject property, on the ground that the kasulutan ng bilihang ganap was falsified and therefore cannot serve as a basis for the issuance of title in the name of Agripina. So the RTC dismissed the complaint. On appeal, the CA reversed and set aside the RTC decision and held that the kasulutan was falsified. And that decision was already final and executed. So there was already a finding that the kasulatan was falsified. Now, the petitioners, Agripina, filed the instant complaints for specific performance against the heirs of Jose. Petitioners pray that the respondents execute the appropriate documents. Remember, the deed of absolute sale was declared as falsified. Now, because they were not able, Agripina was not able to secure a favorable judgment, okay, in the court, they subsequently filed another complaint for specific performance to compel the heirs of Jose to execute the appropriate documents so that the property will be the ownership of the property will be transferred to her. Okay, in this case, the Supreme Court ruled, settled is the rule that a cause of action may give rise to several reliefs, but only one action can be filed. A single cause of action or entire claim cannot be split up or divided into two or more different actions. So in this case, the cause of action pursued in civil case number in the first civil case on which the lower courts rendered their decision was similarly brought in the subsequent civil case. Applying Section 4, petitioners cannot split their cause of action by filing a case in court to recognize them as lawful owners of the property and thereafter file another separate complaint for specific performance that ultimately seeks to determine with finality their title over the same property. So in this case, it was already barred. The second case was already barred by res judicata. Why? Because in the first case, in the petition to annul the kasulatan ng bilihang ganap, okay, on the ground that the same was falsified, okay, there was already a final and executory judgment rendered by the court. Now, because of that unfavorable decision, okay, Agripina went back to the court and filed another case, now for specific performance, to compel the heirs of Jose to execute a document, a deed, which recognizes their ownership over the property. When that issue of ownership has already been settled in the previous case of a petition to nullify the kasulatan ng bilihan. So, it was a clear case of splitting a single cause of action. Okay. Again, another case illustrating what is meant by splitting a single cause of action. This is again a case of loan secured by a mortgage. The creditor has a single cause of action against the debtor, the recovery of the credit with execution upon the security. The creditor cannot split his single cause of action by filing a complaint on the loan and thereafter another separate complaint for foreclosure of mortgage. For non-payment of a note secured by a mortgage, the creditor has a single cause of action. This single action consists of the recovery of the credit with execution of the security. The creditor in his action may make two demands, payment of the debt and the foreclosure of his mortgage. But both demands arise from the same cause, non-payment of the debt. And for this reason, they constitute a single cause of action. There exists only one cause of action for a single breach of that obligation. By applying the rules above, you cannot split up the single cause of action by filing a complaint for payment of the debt and thereafter another complaint for foreclosure of the mortgage. If he does so, the filing of the first complaint will bar the subsequent complaint. Okay. However, in cases when the creditor opts to foreclose the mortgage, let us say the loan amount is 2 million and the amount realized in the foreclosure sale is only 1 million, he can file a suit for collection of deficiency judgment for the remaining amount only of 1 million. Okay? By causing the auction sale of the mortgage properties, respondent effectively adopted the remedy of extrajudicial foreclosure. One effect of the respondent's election is its waiver of the remedy of the collection of the unpaid loan. As petitioner already filed judicial foreclosure proceedings, she is now barred from availing herself of an ordinary action for collection, regardless of whether or not the decision in the foreclosure case had attained finality. The dismissal of the collection case is in order. Now go to the last topic for this session, joinder or misjoinder of causes of action. What is joinder of causes of action? Under Section 5, Rule 2, a party may, in one pleading, assert in the alternative or otherwise as many causes of action as he may have against an opposing party, subject to the following conditions. First, the party joining the causes of action shall comply with the rules on joinder of parties, which will be our next topic, joinder of parties. Second, the joinder shall not include special civil actions or actions governed by special rules. So you cannot combine ordinary and special civil actions, ordinary civil actions and special proceedings. Where the causes of action are between the same parties, but pertain to different venues or jurisdictions, the joinder may be allowed in the regional trial court, provided one of the causes of action falls within the jurisdiction of the said court and the venue lies therein. Okay, so if they pertain to different venues or jurisdiction, like for example, one is cognizable by the MTC, while the others pertain to the RTC. Now, there can be a joinder, okay, provided that it is in the regional trial court. So you cannot have the joinder in the MTC if one of the causes of action that are joined is in the jurisdiction of the regional trial court. And last, where the claims in all the causes of action are principally for recovery of money, the aggregate amount claimed shall be the test of jurisdiction. So the totality rule. Now, what is the remedy? If there is a misjoinder of causes of action, misjoinder of causes of action is not a ground for dismissal of an action. A misjoined cause of action may, on motion of a party or upon the initiative of the court, be severed and proceeded with separately. What is joinder of causes of action? It is defined as the union of two or more civil causes, each of which could be made the basis of a separate suit in the same complaint or petition. So there are two or more causes of action which can be filed as separate cases, but they are joined in a single suit. What is the purpose, primary purpose of joinder of causes of action? It is, of course, to avoid multiplicity of suits, where the same parties and subject matter are to be dealt with in one action, a complete determination of all matters, and to expedite the disposition of litigation at minimum cost. Again, there are rules concerning joinder of causes of action, okay, which we already discussed. Okay. Remember that a misjoinder of causes of action cannot be the basis of a dismissal. Okay? Because a misjoined cause of action may be severed and proceeded with separately upon order of the court motu proprio or upon motion of the party. However, if there is no objection from the opposing party and the court did not motu proprio order the severance of a misjoined cause of action, the misjoined causes of action may proceed simultaneously provided that the court has jurisdiction over all the causes of action. If the court has no jurisdiction over the misjoined cause of action and the same is not severed, any adjudication would be a nullity. Remember that any judgment rendered by the court by a court without jurisdiction is null and void. Okay? We have the case of Paloma versus Magno. So in this case, Esther, Justina, and Cristobal are the legitimate children of spouses del Molin. Now, during Santiago's lifetime, he was the registered owner of a parcel of land. Santiago sold the property to Justina. Now, after 3 decades, title was transferred to Justina. Thereafter, Esther requested the land to be partitioned among them, including the heirs of their late brother Cristobal. Justina refused to sign and implement the partition agreement. Now, the respondents filed a petition to annul the TCT that was issued in the name of Justina and to judicially partition the intestate estate of the late Santiago de Molin. So we have two cases, di ba? One is an ordinary civil action to annul a patent. Then another is a special civil action for partition. Now the question is, can you join both actions? Do they comply with Section 5 of Rule 2. Okay. The Supreme Court said a misjoinder of cause of action is not a ground for dismissal of an action, and that a misjoined cause of action may be severed and proceeded with separately. In this case, while the court may have overlooked the misjoined actions, such fact is not a ground to assail the validity of the decision or a ground for the dismissal of the case. Absent any objection on the part of the petitioner or a directive from the court for the annulment of title and partition to proceed separately, both causes of action were validly adjudicated upon, considering that the court has jurisdiction over both causes of action. Okay. As a general rule, in the case of Paloma versus Mag, illustrates a misjoined cause of action. Why? Because the petition for annulment of title is an ordinary action, while the case of partition is a special civil action. So the Section 5 of Rule 2 states that they cannot be joined together. Why? Because they are governed by different rules. Special civil action for partition has a special set of rules which is not applicable to an ordinary civil action of annulment of title. But the case proceeded, di ba? And there was judgment that was rendered. The RTC has jurisdiction over both actions. There was no objection on the part of the other party. There was also no motu proprio action from the court, okay, to dismiss the partition and order it to proceed separately from the annulment of title case. So the Supreme Court said there was a valid judgment that was rendered, even though there is a misjoin there. Why? Because misjoinder of causes of action is not a ground for dismissal of the case unless the court trying the case has no jurisdiction over either of the causes of action. Okay? We have the case of Pantranco. It's a standard. So in this case, Crispin was driving a passenger jeepney owned by Martina. It was then raining. Now, while driving along the national highway, a passenger bus owned by Pantranco and driven by Alexander was trailing behind. When the two vehicles were negotiating a curve along the highway, the passenger bus overtook the jeepney. In so doing, the passenger bus hit the left rear side of the jeepney and sped away. So the total cost of the repair was 21,000, but the respondent standard paid only 8,000. So Martina shouldered the balance. Now Standard and Martina demanded reimbursement from Pantranco and its driver, Alexander, but they refused. This prompted the respondents to file with the RTC a complaint for a sum of money. So remember, we have two causes of action. Okay? Martina, based on quasi-delict, because of the fact that Pantranco violated his right to operate or drive the vehicle safely along the highway. On the other hand, Standard, because of the substitution, his substitution as insurer of the jeepney. Okay? He was substituted to the rights of Martina to collect from Pantranco and the driver the amount that he paid to Martina. Okay. So there is a single transaction which is common to all. That is Pantranco's bus hitting the rear side of the jeep. There is also a common question of fact, whether petitioners are negligent. there being a single transaction, consequently, they have the same causes of action against the petitioners. To determine identity of cause of action, it must be ascertained whether the same evidence would necessarily sustain the second cause of action would be sufficient to authorize a recovery in the first. Such joinder of parties avoid multiplicity of suit and ensures the convenient, speedy, and orderly administration of justice. Now move to the case of Lahabe versus Habelian. In this case, the issue is whether during the pendency of Agustin's complaint for unlawful detainer, he can also independently maintain an action for collection of sum of money which allegedly stemmed from incidents occurring before the possession by Lahabe of the leased premises became unlawful. Okay, so we have a case wherein there is a case for unlawful detainer, which was filed by Agustin. Okay, now before the case for unlawful detainer arose, okay, there were collectibles, okay, by Agustin from Lahabe. So can they be joined in the same uh, case, in the same case. While the complaints appear to involve the same parties and properties, we find no identity of causes of action. In the unlawful detainer cases filed by Agustin, in view of Lahabe's failure to vacate the properties and non-payment of rentals, his cause of action stemmed from the prejudice he suffered due to the loss of possession of his properties and the damages incurred after the dispossession. Meanwhile, in the complaint for collection of sum of money, the same was founded upon the violation of Lahabe as lessee of certain stipulations with regard to the payment of lease, whether Lahabe correctly paid the rental fees for the period stipulated in the lease agreement. So can you join unlawful detainer and collection of uh, unpaid rentals? The resolution of whether Lahabe paid the correct rental fees and if there is a deficiency in the payment of rentals requires a full-blown trial through the submission of documentary and testimonial evidence, which cannot be passed upon in a summary proceeding. Okay? The damages recoverable in an ejectment case must have a direct relation to the loss of material possession, giving rise to an action for illegal detainer. These are damages caused by the loss of the use and possession of the premises. The deficiency in rentals could not be included in the damages to be awarded in the ejectment cases, for these were sustained prior to the dispossession of the unlawful withholding of possession. So you cannot join them in one action. Okay? Unlawful detainer as well as the collection of unpaid rentals. In an action for collection of sum of money may not be properly joined with the action for ejectment. The former is an ordinary civil action requiring full-blown trial, while an action for unlawful detainer is a special civil action which requires summary procedure. Agustin's filing of a complaint for collection of sum of money other than those sustained as a result of their dispossession or those caused by the loss of their use and occupation of the properties who does not be considered as splitting a cause of action. The cause of action is different. Since the damages prayed for in the collection case before the METC pertain to deficiency in rental payments for the contested period before the dispossession. The claims have no direct relation to the loss of possession of the premises. This cannot be litigated in the ejectment suit by reason of misjoinder of causes and action. Okay, we now move to the case of Abelia versus Abelia. So this is a case for support. Now, is there a necessity to first file a case? Okay, establishing the filiation of the person who is seeking support before you can file an action for support. The Supreme Court said, the issue in this case is whether the CA erred in ruling that filiation proceedings should have been first separately instituted to ascertain the child's paternity, and that without these proceedings having been first resolved, petitioner's action for support would not prosper. Okay. So in this case, the Supreme Court said an integrated determination of filiation is entirely appropriate to the action for support filed by the petitioner. Remember, an action for support is a special civil action. Now, an action to establish the paternity or the filiation of a child is a special proceeding. Okay. Now, an action for support, the Supreme Court said, may very well resolve the ineluctable issue of paternity if it involves the same parties, is brought before a court with proper jurisdiction. This is in keeping with the rules on proper joinder of causes of action. This also serves the interest of judicial economy, avoiding multiplicity of suits and cautioning litigants from the vexation and cost of a protracted proceeding. So even though they are governed by different rules, the Supreme Court said you need not file a separate action for establishment of your filiation. You can just prove your filiation in the action for support itself. That is the ruling in the case of Abelia. The case of Salvador, the Supreme Court said, having joined two can an action for injunction and quieting of title be joined in one proceeding. Remember that an action for injunction is a special civil action, while quieting of title is an ordinary civil action. The Supreme Court said no. The RTC should have severed the causes of action either upon motion or motu proprio and tried them separately, assuming it had jurisdiction. Okay, the refusal of the petitioners to accept the severance would have led to the dismissal of the case conformably with the mandate of Rule 70. Okay, so if, for example, the court motu proprio ordered the plaintiff to sever the other cause of action, and he did not comply. Okay, that is the time when the court may order the dismissal or the severance of the misjoined cause of action. Okay, but misjoinder itself is not a ground for the dismissal of the misjoined cause of action. It is only when there is an order for the severance of the same and the plaintiff did not comply with the said order that the court can order the dismissal of the misjoined cause of action. Okay. We have the case of Genesis versus Spouses Lim. Okay, it is clear that the respondent's complaint is a complaint for declaration of nullity of documents, partition, recovery of shares, and damages. Respondents sought to recover ownership and possession of their shares in the disputed parcel of land by questioning the due execution and validity of the deed of extrajudicial settlement with sale. Respondent likewise sought the nullification of the tax declarations as well as the partition of the property in litigation. This is a case of joinder of causes of action which comprehends more than the issue of partition or recovery of shares or interest over the real property, but includes an action for declaration of nullity of contracts which is incapable of pecuniary estimation. Where the causes of action are between the same parties but pertain to different venues or jurisdictions, the joinder may be allowed in the RTC provided one of the causes of action falls within the jurisdiction of the RTC and the venue lies there. Thus, the respondent's complaint clearly falls within the jurisdiction of the RTC. Okay? The last case is the case of Ada versus Bailon. Okay, can partition and rescission be joined in a single suit? Remember, partition is a special civil action, while rescission is an ordinary civil action. They are governed by different set of rules. Okay, now it is the union of two or more civil causes of action, each of which should be made the basis of a separate suit in the same complaint, declaration, or petition. Of course, the objectives of filing one suit for two or more causes of action is to avoid multiplicity of suits. So in this case, the court held partition and rescission, there was a misjoinder of causes of action. The action for partition would not be joined with the action for rescission of the donation. An action for partition is a special civil action, while an action for rescission is an ordinary civil action, governed by the ordinary rules of civil procedure. The variance in procedure precludes their joinder in one complaint or their being tried in a single proceeding to avoid confusion in determining what rule shall govern the conduct of the proceedings. However, misjoinder of causes of action is not a ground for this reason. The courts have the power, acting upon the motion of a party to the case, or sua sponte to order the severance of the misjoined cause of action to be proceeded with separately. However, there is no objection to the improper joinder and the court did not by itself direct a severance, there exists no bar in the simultaneous adjudication of all the erroneously joined causes of action. If the court trying the case has no jurisdiction over a misjoined cause of action, then such misjoined cause of action has to be severed from the other cause of action. If not, any adjudication rendered by the court with respect to the same would be invalid. In this case, Florante posed no objection, and neither did the RTC direct the severance. Thus, the RTC validly adjudicated the issues raised in the actions for partition and rescission filed by the petitioners. So that's it for cause of action under Rule 2. Thank you for listening.